Hello friend, I am P.C Jangir, Vice Principal in Biyani Group of College. Welcome you all on behalf of the Guru KPO. Our present topic is lifting of the corporate veil. For the first time we have to know what is the meaning of lifting of the corporate veil. It is also known as piercing the corporate veil. There is a well-known principle in case of the company that the company is having the separate legal existence. It means members and company are different. The property of the company is the property of the company. Shareholders are just the members of the company. And the members' liability is very limited. Therefore, there is a provision of separate legal existence. But as and when, if there is any anomaly, if there is any description, if there is a fraud, if there is a misrepresentation, if there is any scam, if there is any scandal, if there is any misappropriation of the funds of the company, or the company is running for the illegal purposes, in such a question, the question mark rises. If there is any distrust or fraud or misappropriation or misrepresentation, or company and the members are indulged in some of the nefarious activities or illegal activities. In such a case, an inquiry can be conducted by any person or the member of the company or the company law board or the government or the public that the corporate wealth should be lifted. At that time, separate legal existence and limited liability concept will not be applied. This is known as the lifting of the corporate veil or piercing the corporate veil. In Urdu it is known as company ko benaqab karna. As and when a person or a woman is married, it is well-known truth that earlier acts will not be revealed after it. But if there is any misappropriation, scandal or illegal activity, in such a case, the veil is lifted and investigation may be conducted against each other. In the same way, if there is a fraud, if there is a misappropriation, if there is a scandal, if there is a scam, if there is misappropriation, in such a case, corporate veil is lifted. In company law, there are two types of provision for the lifting of the corporate veil. They can be basically categorized into two categories. Number one, under statutory provision, and number two, under judicial pronouncements. So far as the first one is concerned, under statutory provisions, there are various provisions in which the corporate veil can be lifted. Number one, reduction in the minimum number of members. In a private company, minimum 2 members are required. In a public company, minimum 7 members are required. And if the minimum numbers are reduced from 2 to 1 or nil, or from 7 to lesser, in such a case, if the company is conducted the business for 6 months without informing the company law board or the company registrar, in such a case, the liability of the member will be assumed as unlimited and separate legal liability concept will be waived. The another situation, that is in case of the failure of return of application money. Every person who wants to get the share of a company, he may apply for the share in a company. If the members, if the subscribers send the money to the company and the application, if it is oversubscription and company is unable to provide share to him, in such a case, such amount is to be returned. If after some of the certain day or the time, the money is not returned, in such a case, the inquiry can be conducted and corporate wealth will be lifted. The third one, misdisclosure the name of the company. There are certain documents of the company and the common seal is to be used. In place, the real name of the company, the fake or artificial name or any name which is not true. In such a case, any person can lodge a case against the company and the corporate wealth can be lifted. The fourth one, the holding company and the subsidiary company. If the government or the company law board requires, there should be distinction between the holding company and the subsidiary company, or if the government demands that there should be the holding company as well as the subsidiary company, it should be depicted. In such a case required, it should be depicted. Otherwise, the corporate wealth can be lifted. The fifth one, for investigation. Investigation means if there is a fraud, if there is a misrepresentation, if there is a misappropriation of the income of the company, if the company is sham, if company is doing some illegal activity, any person, if lodge a FIR against the company, the investigation may be conducted and the corporate wealth will be lifted there. The sixth one, ownership of the company. Sometimes there is a misrepresentation or fraud or any type of anomalies there, misappropriation of the funds are there. In such a case, the corporate wealth will be lifted. Who are the person behind it? They can be examined. The seventh, unlimited liability. If a director of a company, suppose he assumes unlimited liability, but after, if there is a scandal, then the unlimited liability will remain as a concept. Limited liability will be waived, and fraudulent trading activities are there, or in case of the non-payment of the taxes, corporate wealth will be lifted. Thank you, thank you, thank you.